Hello. We just held this morning a roundtable session at the OECD's Competition Committee on gun jumping and suspensory effects of merger notification. And one of our expert panelists there was Jay Modrall, who is partner at Norton Rose Fulbright in Brussels. And you represented the private practice side in this discussion, which was extremely helpful and valuable for our agencies to talk to you and to hear your experiences. Now, since you represented the private practice side in this gun jumping session, was there anything in the session that you found most remarkable or unexpected? Any takeaways?
Well, I think the most remarkable aspect of the session, in fact, was that it took place at all. Gun jumping rules have been around for as long as merger control has been around, and there are more and more cases every year, and the fines are getting higher every year. But so far as I know, this is the first time that anyone has taken a systematic look at gun jumping enforcement and legal issues around the world.
I mean, from your practice, you have very different insights that we can have from the agency side. What's actually hardest when businesses in a merger process try to reconcile their business needs with the legal requirements of the merger control regimes? So where are the real issues from your perspective?
Well, it depends very much on what kind of party you're talking about. If you're an industrial company, a major multinational that engages in a lot of M&A activity and has a very strong central management, then you've probably already got the systems to collect the information you need to decide where you need to notify, and you've got the local council networks to make those notifications.
Yep.
Where you often do have issues, though, as an industrial buyer, is in managing those businesses, both your existing business and the target business, in a way to ensure that there's no premature implementation, no exchange of competitively sensitive information, while at the same time engaging in appropriate planning activity. And that can be a big challenge. If, on the other hand, you're a financial buyer, a private equity buyer, and there are more and more transactions involving private equity, you don't have typically a strong central management. You don't have horizontal systems that collect data across your portfolio. And even the process of figuring out where you need to notify can be very difficult.
Yeah. In the light of your experience with multinational mergers, so mergers that need to be filed in a number of jurisdictions in parallel, what do you think, or what are the major needs for coordination between the competition authorities in this regard to make the lives of businesses that want to comply with the rules easier?
Well, it's interesting to hear the discussion this morning, because one thing it revealed is that there is a huge range in the practice of different authorities. There is a difference in approach in the enforcement itself, from advocacy, educating people about the existence of the merger control regime, to imposing very high fines that are set even higher for a large company in order to ensure that there's a sufficient deterrent effect. So there's just a huge range. And whether there's a need for coordination, probably not. Each country has its own statutory regime, and I don't think that's going to change. I think there are some areas, though, where each authority could benefit from clarifying its approach, possibly with the guidance of the OECD, including, for example, the factors that they will take into account in deciding what kind of sanction level to impose, if any, and also what distinctions to be made between conduct that violates the merger control regime and conduct which violates the local statute against anti-competitive behavior, like Article 101 in the EU.
Yep. That would be my next question, actually, because, I mean, we talked to a good extent about the Ernst & Young judgment, and of course that made it very clear that Article 101 can be applied to violations that happen in the merger process, where the merger provisions are not applicable, to information exchanges between competitors that in the pre-closing period. What's your guess? Do you think we're going to see more of that in Europe? Because in the US it's standard practice to apply Article 1 of the Sherman Act and the Hart-Scott-Rodino Act in parallel.
Yeah. Well, there aren't that many cases in the US either. And in the EU, we had to wait from 1989, when the first merger regulation was adopted, until earlier this year for the Altice case. So there's no telling how long it's going to take. On the other hand, the Commission is clearly focusing on what they view as procedural violations of the merger regulation. So I think we will continue to see more cases than in the past, maybe not one every year, but still more often. And in the light of the E&Y case, I think it would be very surprising if in the next case the Commission does not proceed in parallel under the merger regulation and Article 101, not exclusively under the merger regulation as an LTIS.
That's a very interesting conclusion, and well, it will stay fascinating. I think that's a topic that's here to stay. And
very much so.
Jay, thank you so much for helping us with this and for contributing to our discussion. It was a pleasure to have you. Thank you so much.
And thank you, Sabine, for organizing. It was a huge amount of work and a great success.
Thank you very much.
Okay, thank you.
Bye.